The Chair now recognizes the ranking member of the Constitution Subcommittee and the gentleman from New York, Mr. Nadler, for 5 minutes.
I thank the Chairman. My first question, I must give credit to David Cole in the March 4th issue of The Nation. I'm just going to read the question he posed. Imagine that Russian President Vladimir Putin had used remote-controlled drones armed with missiles to kill thousands of quote-unquote enemies throughout Asia and Eastern Europe. Imagine further that Putin refused to acknowledge any of the killings and simply asserted in general terms that he had the right to kill anyone he secretly determined was a leader of the Chechen rebels or associated forces, even if they posed no immediate threat of attack on Russia. How would the State Department treat such a practice in its annual reports on human rights compliance? Anyone? We start with Mr. Bellinger.
Thank you, Mr. Nadler. In fact, as I alluded to in my opening remarks and at greater length went into my written remarks, I mean, this is a real problem. It could happen this year where the poor State Department spokesman is going to have to stand up after Russia or China has used a drone against a dissident in the next country, and the State Department will have to explain why that was a bad drone strike in comparison to the United States that, of course, only conducts good and lawful drone strikes. And so that is extremely important for our government, both Congress, but primarily the executive branch, to lay down as precisely clear rules for the use of drones.
That's fine, but isn't it the case that if Russia or China or someone were doing what Mr. Cole posits, that we would condemn that out of hand, that we wouldn't say, well, you know, this drone strike was okay and that one wasn't, that we'd say...
If Russia or China were being attacked by a terrorist group that was indisputably posing imminent...
Well, the Chechens attacked them at one point.
And if Chechens were in another country posing imminent threats to Russia, and the country that they were in was unwilling or unable to prevent that threat, I think we would have to acknowledge Russia's right to defend itself.
Okay. Let me continue. First of all, one comment on something Mr. Bellinger said. He said we need due process, but not judicial process. I don't understand, and I'm not asking a question, I'm just saying I don't understand how a unilateral determination by an executive branch official without any judicial involvement can be considered due process in any form. But let me ask Mr. Wittes the following question. You said, and the white paper says, that we can attack senior operational terrorists posing an imminent threat consistent with the laws of war. My question is the following. I don't understand why we need a senior operational terrorist, why he can't be just an ordinary terrorist. I don't understand why he has to be posing an imminent threat. I think the analysis is completely different. Either this person is an enemy combatant or he's not. If he's not an enemy combatant, he's subject to the normal criminal law, and we ought to have normal due process and take him to court and so forth. If he's an enemy combatant, he doesn't need due process. The question is, how do you determine whether he's an enemy combatant? And who determines whether he's an enemy combatant? Whether he's senior or not, I don't care, frankly, from this point of view. But under the laws of war, if he's an enemy combatant, he's a legitimate target. But who can determine that? Under what standards? And what precedents do we have? And on what grounds? And how can the executive determine that without any kind of other determination? Let me ask Mr. Wittes and Mr. Vladeck.
Well, I would just say, as a matter of law, you've just taken a position that is far more permissive with respect to targeting than the Obama administration's position.
No, because I've said it's got to be, you've got to determine properly as an enemy combatant.
I understand. You've suggested a narrower process to determine a broader category, right? The Obama administration has taken the view that it generally will not specifically, or that it does not assert generally the right to target any U.S. national overseas who may fit in a law of war category of belligerency. It will target people only when they are an imminent threat and a senior operational leader whose capture is unfeasible. So you're taking a view that is potentially much more permissive and inclusive of more possible targets, but with a concern about the lack of process on the judicial side. I would just say, I think it is a very legitimate question what processes this body wants to impose for making those determinations. My only point is that there's nothing particularly extreme about the substantive position. There's nothing extreme at all about the substantive position the administration has taken about whom it may target. And under current law, which is the law under which it confronted the Anwar al-Awlaki case, which is really the case that gave rise to these memos in the first place, there is no basis for judicial process at all. There's no forum in which to take these questions.
Congressman, all I would say is I share your concerns about the view that due process is not a requirement of judicial process. I was surprised to hear the Attorney General say that last year in his speech at Northwestern. The only thing I think that it's worth bearing in mind is due process is not necessarily a requirement of pre-deprivation judicial process.
Of what?
Of pre-deprivation, right? In other words, there are circumstances where the Supreme Court has said the government is allowed to act, and then we will review after the fact whether they acted with sufficient procedural safeguards. And so I share your view. I think the point is that that's not necessarily, the cash out of your view is not that there should be pre-deprivation judicial process, but rather that there is a requirement that at some point some neutral magistrate is reviewing whether the government's decision was made with adequate safeguards.
Can I just ask Mr. Vladeck to comment on the question of that I posed? Under laws generally, if someone is not an enemy combatant, you cannot target him in any way without due process and a determination. If he is an enemy combatant, well, there are consequences that flow from that. How do we determine? I mean, if someone is wearing a uniform at Normandy in 1944, it's pretty safe to assume he's an enemy combatant, but the wrong uniform, that is. But in the absence of that, how do we determine, and under what safeguards should we determine who's an enemy combatant and not?
So all I'll say briefly, if I may, is the Article 5 of the Third Geneva Convention creates a requirement that when there is doubt about the status of a belligerent, there's supposed to be a hearing. It doesn't have to be a judicial hearing, it can be an administrative hearing, but there is some requirement that at some point, it doesn't have to be before you capture them, it does not have to be before you act, but that at some point, as soon as is reasonably possible, you are ensuring that, in fact, the procedural safeguards that you have implemented have produced the right person. And that's what led to the Supreme Court's Hamdi decision in 2004, saying that, indeed, we need more due process, especially where U.S. citizens are concerned.
Gentleman's time's expired.
Thank you.